Hello again. My name is Frederik Harhoff. I am Professor Emeritus in International Law at the University of Southern Denmark. Last session we discussed slightly the rules of immunity and privileges that apply to state agents in international law. Today we're going to speak about state responsibility, that is to say, what happens if a state violates the rules of international law. In principle, if a state violates a rule of international law, then the state will incur international legal responsibility. And international legal responsibility implies that the state can be brought before a international judicial institution that can verify whether the violation actually took place and, in the affirmative, can set out a sanction. But that happens rarely. In most cases, state violations of international law are negotiated and settled amicably in most cases, although there are some serious exceptions. But in most cases, if a state violates a legal obligation towards another state, then that other state will make a claim to the authorities of the committing state and claim an apology or claim compensation or otherwise claim some sort of indication from the violating state that they accept the responsibility for the crime and promise that they won't do it again. So most cases of breaches of international law are negotiated and settled peacefully, fortunately. If we have, for instance, an invasion, that is to turn to the other aspect, if it is not just an ordinary violation of international law, but really a very serious violation in terms of military attack and intervention of another country, then there are sanctions that will be imposed normally by the international community, because the international community's obligation, basically as a group, is to make sure that international peace and security is maintained. This is also the primary purpose of the United Nations. So in case of a very serious violation, such as a military intervention from one state into another, and we have the example these days with the Russian intervention in Ukraine, that will normally cause a number of severe economic and political sanctions against the violating state, in this case against Russia. And so we have seen that a number of international sanctions have been adopted not only by the United Nations but also by the European Union, as well as by individual member states and individual states outside the European Union against Russia, in order to pressure Russia to stop the invasion and to pull its troops back. But we will see the criminal legal consequences of such an attack later on when we talk about the law of armed conflicts and the use of force. So let's just remain here with the rules that apply to state responsibility. If a state is to be found responsible for a violation of international law, you have first of all to prove either with whatever proof you have in the political negotiations, or if it is brought to a court, you have to prove in court that the violating state knew what it was doing and had the intention to do it. And here we have a quite high degree, or perhaps low degree, of psychological intention, because you don't have the sophisticated distinctions as you have in domestic criminal law about intent and lesser degrees of intent. if a state commits a violation of international law, then the presumption is that the state knew what it was doing and did it deliberately, with intent. So no such thing as a casual violation of international law. No, if a state commits an act that is a violation of international law, then we assume that the state knew that it was doing so and intended to cause the violation. For that violation, of course, the state somehow can be sanctioned. Now, you can't put, you cannot have a criminal case against a state as such. You can have criminal cases against individuals, but you can't put a state into prison, of course. So state responsibility is mainly political and sometimes also legal, in the sense that an international court of justice can hand down a judgment in which it says that the state of whatever state is responsible for the commission of this violation of international law and can impose some sanction, be it payment of compensation or restoration of whatever property was damaged, or in any other way trying to find a peaceful solution to the conflict. If there is a violation of international humanitarian law, then, as I said, only individuals can be held criminally responsible for a crime committed under international law. But the state can sometimes be held not co-responsible, but the part that the state played, for instance, in the crime of aggression, is something that can also be included in a criminal case against the persons who committed who were responsible for the aggression in place. But here you will see that the end of a case, criminal case for aggression, will be that the individual will be punished, but then the state on whose behalf the aggression was committed will very much be a part of the judgments, and it will be clear that the state was also responsible for the aggression. And then you can put, again, political or economic sanctions against the state. So the normal approach to a violation of international law by a state will be that the states will try and meet and settle the issue by peaceful means and by ordinary political means. Hopefully, in many cases, concluding with an agreement of the payment of compensation or otherwise restoration of whatever damage was done. You can bring the case to a court, either some sort of international court, if such a court exists, or before an arbitration, a court of arbitration. And we have several such courts of arbitration that are applicable. For instance, in the World Trade Organization, there's a court of arbitration that can settle issues where world trade order has been disturbed by one state or another. Then the state that has suffered from the violation can bring the violating state before the WTO, the World Trade Organization's court of arbitration, and see if it can be settled there. Also, in maritime law, we have the law of the sea, and we have an international tribunal for the Convention of the Law of the Sea, the ICTY, based in Hamburg, that can settle all international disputes relating to the law of the sea. The simplest thing we can say about state responsibility is, as we have already alluded to, there has to be some sort of an intent on basis of the state. And then the second requirement is that the violating state must accept its responsibility. So if a state commits a violation of international law and it does so intentionally, then the next step is that the state has to accept its responsibility for the violation. Now, there can be a number of instances where the state feels that it is not responsible. What happens, for instance, if there is a revolt going on within the territory of the state, and the revolting forces commit crimes not only in a civil war, not only on the state, but also on neighboring states? Then the neighboring states will complain that, hey guys, part of your soldiers committed crimes on our territories, and so we're going to hold you responsible. And then the state that is struck by a civil war will say, no, I'm sorry, these gentlemen, they acted outside our control. But that is where the neighboring state will then be able to say, okay, we accept that they were not immediately under your control, but you should have prevented them from doing what they did on our territory. And because you did not prevent them from doing that, we will hold you responsible. A good example is the 9/11 bombing of the Twin Towers in New York, where it appeared as if Osama bin Laden was behind this. And so he was at the time living in Afghanistan, and so the US held Pakistan responsible for the attack on the Twin Towers in New York. Because the US said Afghanistan should have prevented Mr. Osama bin Laden from committing these atrocities. That's a hard case because, yes, a state is required to make sure that everything that goes on within its territory does not have any hostile impacts on foreign territory. But it is impossible in all aspects of life to always prevent this. So there will be many instances where the state will have to accept responsibility, but also instances where the state says, sorry, this was outside our control. We couldn't help it. We have many such examples. For instance, in the war between Syria, the civil war in Syria, some of the terrorists on Syrian territory committed war crimes on Iraqi territory. And so the Iraqis asked the outside world to come to its assistance to help fight back these incursions from Syrian territory. And the international community actually did get in and provided troops and assistance to the Iraqi areas, sometimes even crossing the border into Syria and fighting there in order to prevent these attacks from occurring in the future. So there you have a transgression where foreign countries invaded Syrian territory and committed acts of war there, not necessarily crimes, but used armed violence, which is not allowed. And so the issue was, could Syria be held responsible for the attacks committed by terrorists from Syrian territory into Iraqi territory? The answer was, it was obvious that the Syrian authorities did not have sufficient command and control over these terrorist forces that spread their terror across the borders to other countries. So sometimes states can be allowed to say that we did not control the events that took place on our territory, and so we should not be held responsible for whatever crimes or violations were committed. So that is as much as we will say for the moment regarding state responsibility. I thank you very much, and next time we will be looking at the law of the sea. Thank you so much.